Your Lordship, I am on behalf of respondent. The petition has been transferred in July 2023, and the order is to vacate the quarter, Your Lordship. But she has not intended to vacate the quarter, and she has not relieved. She has not gone to the transferred place, Your Lordship. And the stay in this case has been granted in 18/12/2000.
Who is for the petitioner?
Bharat Kumar, Your Lordship.
Post tomorrow.
Advise, Your Lordship.
Your Lordship, it was mentioned one case from the Delhi Consulate at serial number 36. The prayer has become infructuous as the respondents have already appointed the petitioner.
What's your name?
Rishabh.
Rishabh Kumar. Are you advocate on record?
Yes.
Mr. Rishabh Kumar, advocate, submits that the present writ petition has become infructuous and accordingly he does not want to pursue this case any further. Considering the submissions, this writ petition is disposed of as such. Prayer quote कर दीजिए, आप अपना साइन करिए फाइल में.
Subject to gross constitution at serial 39.
39. Yes.
So, sir, is only paying for not to give.
We don't
on
adjourn
behalf of
cases
the
on mention. We do not adjourn cases on mention.
Because it's on the ground of illness of the council.
I understand. So you are not ill, no? Somebody has instructed you. 4:30 बजे तक है ना आप यहाँ पर. So be here. You finish all your work in other courts. One pass over this. कौन नहीं आया? अच्छा कोई बात नहीं, हम छोटा सा ही.
Pass over case. Item 46. The
No,
rupees
no,
6817 of 2023.
Give me both the files. There are few more orders passed.
Yes.
So I'm referring to that. Should I record that you are citing those orders?
My citing order
All those orders are in your favor.
फेवर उसमें रीजन ऑर्डर का जो इसमें बोला गया है कि इन लोग ये नहीं दिए, रिप्रेजेंटेशन नहीं दिए हैं. हम लोग तो रिप्रेजेंटेशन दिए हुए हैं.
कहाँ है बताएं?
मेरा केस में दिया हुआ है एनेक्सर 3 सीरीज.
You are in WPS number 6817.
हाँ सीरीज.
Annexure?
एनेक्सर 3 सीरीज पेज 37
Page 37.
onwards.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner number
4 and 7.
18 and
4 and 7 है.
just a moment. Which 6817?
68.
Okay. The learned counsel for the petitioner has submitted that the petitioners that the details of the petitioners have been mentioned in paragraph 6 of the writ petition, which is as follows, right? Okay, this is what you want to say?
Petitioner number 4,
Yes.
wife of the deceased employee. Petitioner number 4.
It is already mentioned.
Okay.
And the husband of the petition number 4 and 7 were appointed.
हाँ, और ये during service period, petitioner number 7, husband has died. Service period.
Okay, the learned counsel submits that
Petitioner
the petitioner number 4 and 7 are the wife of the employee, and petitioner number 7 had expired while in service.
5.
The learned counsel has submitted that pursuant to various orders passed by this court, the the petitioners have superannuated from service yes, and following payment was made to each one of them, the details of which has been mentioned in paragraph 17 of the writ petition. Correct?
Para 10 my lord.
Para 17?
Para 17 तो वो अमाउंट मिला है इनको.
Yes, you have got this amount.
हाँ नहीं सेमेंट para 10 and 11 superannuated rate.
Okay. The details of the date of superannuation / death has been mentioned in paragraph 10 and 11 of the writ petition. That is all?
Yes.
ये पैरा नंबर कौन सा बताया है? पैरा नंबर 6, 7, नहीं 6 and then 10 and 11. Para number 6, 10, 11 and 17.
ये है para 11 में para 11 में लास्ट सो फॉर द पिटिशनर नंबर 10 नेमली किशोर प्रसाद सिन्हा मतलब किशोरी प्रसाद सिन्हा टाइपिकल एरर है.
Okay, you take care of this.
किशोरी प्रसाद.
Para number 6, 10, 11 and 18. इसको quote कर दें. Okay? The learned counsel submits that that pursuant to various orders passed by this court, ultimately a decision has been taken by the state government wide decision dated by Gazette notification dated 12/8/2023, and consequently the petitioners would be entitled to certain relief in terms of the said notification. He has submitted that the petitioners have represented before the respondent number 2 before the respondent number 2, and accordingly appropriate direction be issued for consideration of their grievance. He has relied upon orders passed by this court in WPS number 5271 of 2023, WPS number 5716 of 2023, WPS number 6478 of 2023, and WPS number 5121 of 2023. You have further respondents?
No, in the first case, the serial number 1.
Considering the aforesaid facts and circumstances, and also the aforesaid orders which have been passed by this court, this petition is disposed of, enabling the petitioners to file their to approach the Secretary, Transport Department, Government of Jharkhand for redressal of their grievance within a period of 1 month from today by filing separate representations along with their supporting document. Upon filing of such representation, the state authority will look into the grievance of the petitioners and pass reasoned orders in accordance with law after granting an opportunity to one authorized representative of the petitioners. हो जाएगा? One person? The reasoned order be passed within a period of 3 months from the date of representation and be communicated to the petitioners through speed post. If the petitioners are found entitled to any monetary benefit arising out of reasoned order, then the Secretary, Transport Department, Government of Jharkhand shall do the needful so that the monetary benefit of the same be also paid to the petitioners within a period of 6 months from the date of the recent order. This writ petition is disposed of in the aforesaid terms. It is made clear that this court has not gone into the merit of the claim of the petitioner, and it is for the aforesaid authority to consider the applicable rules, regulations, guidelines, circulars, etc. governing the petitioner and pass appropriate orders. This writ petition is accordingly disposed of. तो लिखिएगा, no counter affidavit as such has been filed in the present case.
For final score item 1, the received 7479 of 2023. Of 2013.
On the last day, only one fact I failed to mention, one statutory provision I failed to point out. That is the chapter 6C of the Cooperative Society Act.
Cooperative Societies Act.
Section A, capital V. Section 44AV. AV 2, not 1. 1 has contained A, B, C, we are not concerned with 2, where it says autonomy to STCCS. A short-term cooperative credit structure society shall have freedom to decide its financial internal administration matter, especially interest rate on the deposit, loans in conformity with the RBI guidelines, borrowing, investment, loan policy, individual loan decisions, personal policy, staffing, recruitment, posting and compensation to the staff, internal control system. So every autonomy, this chapter was introduced in the year 2011 in the Act. So in view of this provision, the rule action under the rule is not justified. ये point कल छूट गया in the last जी और
अब आप बैठ जाइए प्लीज, हम आपका आर्गुमेंट रिकॉर्ड कर रहे हैं, प्लीज बैठ जाइए.
जी
आई एम रिकॉर्डिंग योर आर्गुमेंट. Although the argument of the petitioner was concluded on 16 February 2024, however, the learned senior counsel for the petitioner has submitted that on the last date, an important statutory provision could not be pointed out, and consequently, accordingly, he refers to chapter Roman 6, capital C of Jharkhand Cooperative Societies Act, and in particular refers to section 44 dash capital A capital B within bracket 2, and submits that the said chapter was introduced in the year 2011, and under the provisions of subsection 2 of section 44AB, there is a provision for autonomy to short-term cooperative credit structure society, and therefore the rules as has been sought to be made applicable to the respondent cooperative society is not at all applicable.
and for the state. I prepared a brief notes of argument.
Give the other side also. इनका notes of argument था कहाँ? नहीं नहीं आपका था यहाँ पर उस दिन आपने फाइल किया था it was there. नहीं नहीं किया ये सब तो साथ में रखना है ना तो दिक्कत होगा इसको टैग करो
है
हाँ this is for the state you
Yes.
do not put at the top as to who is filing this how we will come to know at the time of drafting the judgment by state
By state.
इसको टैग करो yes tell me.
Instead of repeating the facts, I am directly coming to the reply of the points raised by the petitioner in their argument on the last day. The first point they have raised that there has no approval of the cabinet to adopt two-tier system from the existing three-tier system by memo dated 8th October 2002. Lordship, in this reply, I have stated that on the very date the cabinet has also approved this, but inadvertently that was not brought on record. I have annexed the approval with this written notes of argument, Lordship, in the last page.
Have they raised this point in their petition?
No, they have not.
That is why there was no occasion to
Yes,
bring it.
yes, Lordship. I have also stated that earlier this point was not raised by them. In the very last page, Lordship. On the same date it was. सहकारिता विभाग के 733 दिनांक 8/10/2 के में मंत्रिपरिषद के बैठक में 8/10/2 को के मद नंबर 6 में स्वीकृति
Approved on 8/12/2002.
8/10/2000
8/10/2002.
on the same day. When the proposal was sent to the cabinet.
What else?
The second point they have raised that there was an earlier attempt for taking the step of upgradation of the Dhanbad Cooperative Bank, but later contained in memo number 1428 dated 3rd August 2007, and such step was withdrawn at the appellate stage as mentioned in the order dated 13th July 2015, passed in LPA 80 of 2009. Lordship, earlier they have not raised this point in their petition neither they have argued this point earlier. And the earlier steps of upgradation of the Dhanbad Central Cooperative Bank and its withdrawal has no concern with the present action of the state of amalgamation of adopting two-tier system from existing three-tier system, and the decision of amalgamation of the 8 district cooperative bank with the Jharkhand State Cooperative Bank. This point was also not.
There is no such plea?
No pleading in this. The third point they argued on last date that the conditions precedent for the amalgamation, the approval from the Reserve Bank of India has not been taken in the instant case, and accordingly the entire action of the state is vitiated. This argument of the petitioner is not correct. As by letter dated 11/10/2013, Reserve Bank of India pleased to accord in principle approval to the proposal of the government of the Jharkhand for amalgamation of the 8 district cooperative bank in the Jharkhand with the Jharkhand State Cooperative Bank, and the later dated 11/10/2013 of the Reserve Bank of India was brought on record by the answering respondent in annexure F1, page 29 of their supplementary counter affidavit dated 18/8/2021.
Annexure F1 by RBI?
Lordship,
This has been brought on record by RBI or
by,
state?
by the state in
By
their
the
counter affidavit. In supplementary counter affidavit dated 18/8/2021
Just a minute.
as annexure F1.
18/8/2021.
F1. I have also incorporated all these in my written notes of argument in page 9.
Yes. Then,
The fourth point, they have argued that the Rule 39 of the Jharkhand Cooperative Society Rule 1959 does not apply to the cooperative bank, as the same is applicable only for the amalgamation of the cooperative society, such as primary agricultural cooperative society, PACS, and the large area cooperative society. I like to first place the definition of the central cooperative bank.
no, they have argued that it is not applicable to the respondent cooperative society.
It is not applicable on the bank,
Yes, on the bank.
as the same
And
is
it is
applicable
applicable for amalgamation of primary agriculture cooperative
Cooperative
societies.
They have argued that it is only applicable for the society, not for the banks.
That's right.
Section 2(n). In section 2(n), the central cooperative bank has been defined.
Okay.
Section 2(n) of the Jharkhand Cooperative Society Act 1935. I may be permitted to read it. The central cooperative banks mean a central society engaged in the business of banking. This is the definition of the central cooperative banks. So a central cooperative bank is also a society, which also does the business of banking.
So central cooperative.
Bank means a central society.
Just
Section 2(n).
central society. So it is also a society.
It is also a society. So it comes under the preview of the society. My contention is it comes under the preview of society.
Yes.
This is also relevant to the Dhanbad Cooperative Bank is a registered society who also does the banking work after taking the license from the RBI. The registration of the bylaws, amendment, audit, and election of the managing committee of the Dhanbad Central Cooperative Bank were done as per the Jharkhand Cooperative Society Acts and the Jharkhand Cooperative Society Rules 1959. So the registration were done as per the rules. They can make amendment in their bylaws as per the rules. Their audit, their election of the managing committee, all were committed, all were done as per the rules. So they can't say that on the Rule 39 is not applicable upon them. Section 11. Section 11 of the Jharkhand Cooperative Society Act 1935 explain about the registration, how a registration will be done in the society. I may be permitted to read this.
Yes.
Section 11 of Jharkhand Cooperative.
Yes, we are aware of that. They are basically they get their registration, the bylaws, everything is as per the Cooperative Society Act and the rules framed
Act and the
therein.
rules.
So they are governed by the provisions of this. But they specific, they do not say that the rules do not apply. Their case is that Rule 59 does not apply.
Rule 39 does
39 does not apply.
not. They deviate from the Rule 39 saying that it contains the word society. And the definition of from the definition of the central cooperative banks, it is clear that the central cooperative banks mean a central society engaged in the business of banking.
That's
It is clear that the central cooperative bank is also a society. So the Rule 39 is also applicable upon them.
You have to also see clause O after it.
After and the clause
Clause O.
O. clause O defines the central cooperative society. Means a cooperative society which is different from federation and union, and which has any other cooperative society, and if the bylaws so provide individuals as its members. Huh?
Probably something my learned friend is missing. Probably my learned friend is missing.
You can read it from your book.
Ah,
You read it from your book. Let's
Yes.
forget his book.
my Central Cooperative Bank, first definition N he says, Central Cooperative Bank means a central society that has subsequently been defined.
No, you just said that he's missing something.
Yes.
So let us
The
read
central-
whatever it is missing.
Yes, the Central Cooperative Society which has any other cooperative society, and if the bylaws so provide individuals as its member, we are not concerned with this line, provided
We
that.
don't argue. He has read something. You just said that something is missing. So I just wanted to know that what is it that is missing. Let him conclude his argument.
My,
He has not disturbed you.
acha,
So he is referring to section 2O. Section 2O, right? 2N and 2O.
2N and 2O.
That's
and,
right.
let him complete. my lord.
Yes, let him complete.
Then from the above fact, it is clear that the rule 39 of the Jharkhand Cooperative Society Rule 1959 will also apply on the cooperative banks.
That's
So this matter is only a clash between the larger interest of the cooperative credit society of the whole state of Jharkhand and the interest of the single cooperative society like the petitioner society.
That's
So they have only made 4 arguments, 4 points.
That's it. This is all they have argued. They have just now argued one more point. They have just now argued one more point regarding section 44, chapter 6. On that day did not argue. On that day this argument was not advanced, but today they have argued.
Yes, Lord. It says that a short-term cooperative society structure society shall have the freedom to decide its financial and internal administrative matter, especially interest rate on the deposits, borrowing and the investments, loan policy, personal policy. This section defines about their internal decisions. We are not disturbing that. This is the policy decision of the state to convert the 3-tier system into a 2-tier system. So now this central cooperative society will not remain in existence after the amalgamation, and only 2-tier system will be created in the state of Jharkhand.
That
So
is
this
all.
will not help them.
That is all. The learned counsel appearing on behalf of the state while opposing the prayer of the petitioner has submitted that since the point regarding approval of cabinet was not raised in the writ petition, the document in connection with the same was not annexed. However, he has produced a copy of the decision dated 8/10/2002 along with his notes of argument to submit that the required approval of the cabinet was taken on 8/10/2002 itself. The learned counsel further submits that so far as the plea regarding non-approval from Reserve Bank of India is concerned, in the supplementary counter affidavit filed by the state, one document dated 11/10/2013 has been annexed as Annexure F by 1, which reflects that in principle the RBI had approved for amalgamation of all the cooperative societies. All the 8
Cooperative, central, district cooperative banks.
district cooperative banks. Supplementary affidavit का date है 18/8/2021. With regard to the applicability of the rules of 1959, the Learned Council has submitted that the respondent cooperative society is fully governed by the provisions of Cooperative Societies Act as well as the rules. Their registration, approval of rule, amendment to their registration, approval of bylaws, amendment of bylaws, etc., are all governed.
Election of the managing
Election
committee.
of the managing committee, etc., are all governed by the provisions of the rules, Act and the rules, and therefore it is not open to say for them to say that the rules are not, that Rule 39 is not applicable upon them. He has also referred to Section 2 within bracket N of the Cooperative Societies Act to submit that it defines Central Cooperative Bank to include Central Society. And he has also referred to Section 2O of the Act of the Cooperative Societies Act, and has submits that the Central Cooperative Society has also been duly defined. Central Society has also been duly defined. The decision is of which year?
Decision is impin order is of 2013.
There has been an amendment in 2015.
2015, the definition.
There is an amendment in 2015 with regard to the definition of Central Cooperative Society.
Decision
As
is of 2013.
2013.
They have the impin order is of
You can just have a comparison. निकालिए उनको, चलो बच्चों।
The earlier definition was in the rules one. CEA has been shifted from rules to act. Earlier definition was in Bihar Cooperative Societies Rule 1959, which was without
I'll just, you will get that. Which rule was that? Rule number?
earlier rule was original Rule 2 XI.
आप दे दीजिए प्लीज वो किताब वापस. However, during the course of arguments, it transpired that the Central Society was duly defined under the Bihar Cooperative Societies Rules 1959 in Rule 2 within bracket Roman 11. Which was also the same definition as section 2 within bracket O. There has been certain amendments in the section Wide Act 21 of 2015. Central Society, where is it defined? And Central Cooperative Society has been defined under section 2 within bracket O. In the year 2015. By Act 21 of 2015. I want this amendment act. You just get me the gazette notification, because every section might have a different date of effectiveness. Right? You will get that. As a state, you will be in a position to provide it. Right? Act 21 of 2015 will be required. Okay. The Learned Council has submitted that since the entire affairs of the respondent cooperative society is governed by the provisions of respondent cooperative banking society is governed by the provisions of the Act and the rules, it is not open to the petitioner to say that the Rule 39 of the rules do not apply to them. This is your case. So far as the provision of Chapter 6C, Section 44, what was that section, sir?
Section 44 AV2.
AV.
page 55
In this book,
of this book.
page 55. So far as the provisions of section 44 AB within bracket 2 is concerned, the learned counsel has submitted that the same relates to the matters mentioned therein and has nothing to do with the provisions of amalgamation of different district cooperative societies wherein the tier 2 is sought to be eliminated. This is your case? That is all? RBI?
Yes. Ladyship, my submissions are confined to very few facts. We have brought on record only 3 documents.
According to you, approval granted, not granted? What is your specific stand? Don't tell us that you have filed the documents and that is the end of the story.
No.
You have to take a
With the help of
specific
document,
stand.
what I have tried to say is the crux. The approval was there for 8 in principle. That approval, RBI's approval was conditional upon compliance with Rule
39.
38. And Rule 38 requires consent of the bank. That never came. The reason may be whatever. The reason here was that there was a stay order. But the Rule 38 having not been complied with regard to this bank, when there was a revised approval prepared, the document says this revised approval is in supersession of impartial modification of the in principle approval is the language. So when that came and later on the final approval came, the final approval was for 7 banks only. So not for that. Long and short of the story, so far as RBI's stand before the court is concerned, is this only. I'm not neither supposed to support this party or that party, whatever be the dispute.
So
Someone
because
legal-
of interim orders passed by this court, there was no compliance of Rule 38. Therefore, the second stage could not come up. Please, I will come to you, I give you time, please don't disturb like this.
So 38's consent was not available. When the state was faced with this situation, they pressed into service Rule 39. And when Rule 39 has been
It
pressed
is
into
one thing to
service,
say that it was not available, it is another thing to say that there was another approval required after
when-
compliance
yes,
or non-compliance.
Yes, when Rule 38 could not be pressed into service, whatever was the reason, they went for Rule 39. And Rule 39.
That's right. For Rule 39, is there a separate approval required from RBI or just one? In principle, they approve, that's the end of the
No,
story.
Rule 39 would require approval.
From where do you say this? That Rule 39 will have a separate approval?
44A,
Sorry.
44A, that provision which says in the Parent Act itself.
Okay, let us have a look at it. 44 AK.
No order sanctioning a scheme of compromise or arrangement or of amalgamation or reconstruction or division and so on so shall be made without the previous sanction in writing of the reserve.
In principle, there is an approval, but the process, whether first step or second step, is there any provision that if it is declined, then prior to going for a forced amalgamation, then a fresh approval of RBI is required? Is it your case?
On face of it is not there.
Please don't make arguments which is beyond your pleadings and beyond your records.
Leadership.
RBI is a, they are very careful in filing their affidavits.
So we have only
They
said
do not file affidavits casually,
yes,
right? It is vetted at different levels, so please stick to your
yes,
affidavit.
yes.
Please
So-
don't try to assist the court on such provisions and on such things
Which are not part of
which
my
are not
affidavits.
your concern,
Yes. Yes.
right?
I retreat on that aspect.
Yes, so
I-
whatever you have
therefore I
stated that
simply
in principle there was an approval.
There was an approval with regard to 8. There is a revised proposal which is with regard to 7.
With regard to 7, and ultimately only 7 was granted, and there was an interim order by this court.
That's
This is your clear case.
Your Leadership, I want to assist on one thing. Where they have said now today that they have come up with a document which is of course not on record, but they have come up with a document.
Naturally, because they raised a plea which is out of the record, so they have also tried to satisfy the court on the basis of some.
Petitioners relied upon 106 Evidence Act.
That's right.
The provision to be relied upon first is section 114 of the Evidence Act. It says court must presume that official transactions have regularly taken place. It only court may presume. Therefore, had they brought on record, had they challenged, had they at least pleaded, then matter would have been different. Then the other side was under a requirement to place on record something to rebut it. Since they have not said anything, therefore I will request this honourable court to present to service section 114 and presume that official transactions have regularly been done.
And out of this particular transaction only, rest of the 7 banks have been amalgamated. If this goes, then all the amalgamation would go. Please don't, just a moment. It will have a bearing on all the amalgamation also. If this court finds that there is no cabinet approval, then it will have a bearing on all the amalgamated banks.
Cabinet approval in any case, Your Leadership, that's another point. Cabinet approval requirement is not taken.
I don't know. That I have already
Rules of
recorded.
executive business,
They have
said
not
that they
placed any rules of merely because they say that there is a rule of executive business. We cannot.
Even otherwise, Your Leadership, rules
judicial
of
notice
executive
on
business are held to be not mandatory except in cases where there is a financial implication.
Likhiye, the Learned Counsel appearing on behalf of the Reserve Bank of India has reiterated the stand taken by RBI in their counter affidavit. He has stated that in principle there was an approval by RBI for amalgamation of all the 8 banks, but ultimately there was a modification and the approval was granted only with regard to 7 cooperative banks. The Learned Counsel has submitted that there was an interim order passed by this court. In this case,
that aspect will be given up. I am not asking.
all right. The Learned Counsel इसको last का interim order का कहानी बंद कर दीजिएगा. उसके बाद लिखिएगा. The Learned Counsel has submitted that he has referred to section 114 of the Evidence Act to submit that as per the Evidence Act, all the official transactions are supposed to be
Maybe the 114
may
is discretionary.
be, may be assumed to be taken in accordance with law
regularly performed.
in regular course of business of the state, unless there is a specific challenge to such action. That is it? Yes. Who is next? Cooperative bank. Yes. What do you have to say? Have you prepared your notes? No.
I have prepared because I have given also.
You have given. I have not seen it. Please give it to me once again.
It's a very short issue.
Please give it to me. Give your note once again. Before you start, I have a few queries. Please let us know. One is, this bank, has it ever challenged the action? No.
Bank in independent capacity is not it. Because when this was challenged, the bank was under supersession. The election of the board came to be first done in 2018, after about more than 15 years. Therefore, as on today, these 2 petitioners who are shareholders and are the part and parcel of the bank, I am not opposing their prayer,
Supporting.
Perhaps may take it in converse, but I am not opposing, rather supporting. Because I have suggested the bank that go for another writ petition. But what transpired ultimately, that it is an issue which is to be considered by this court instead of increasing the docket of the court, the issue may kindly be considered, Milos. Plus, two issues are only there, Milos. With respect to two provisions, the Cooperative Society Act, Milos, that is 44AK, which came to be inserted, Milos, in 1981 for the first time in the Act. And the Rule 39 of the Bihar Cooperative Society Rule 1959, which admittedly, Milos, pertains to the period when this amendment and incorporation of 44AK was not there. So, Milos, my endeavor would be, Milos, first of all, to justify that the sweep of Rule 39 of 1959 rule will not envelop the, Milos, even the genesis of the cooperative bank at all, because it was not there.
When were you registered?
As a bank,
When were you registered as a bank?
I was 1929.
Bank, your lordship on bank,
District Central Cooperative Bank,
1920.
Dhanbad. When
Dhanbad
was
Central-
it registered? Sir,
Dhanbad
please,
Central-
I am asking
Dhanbad
the question
Central Co-
directly to the bank. Let them.
Dhanbad Central Cooperative Bank came in existence, Milos, about in the year 1929-30. Exact date I will give, Milos.
So, if these rules are not at all applicable to you, why did you get yourself registered under the rules? This rule is not applicable.
Plus, banking license came to me in 1995.
So, banking license came to you in 1995.
Grateful, Milos,
Okay, then
under the RBI Act.
Then what happened?
Then what happened, Milos? Kindly see.
No, just a minute. You say that Rule 39. If this rules of 1939, perhaps.
Rule 39 of 1959.
1959 rules will not cover any of the cooperative bank.
Bank particularly. Why I beg to humbly
Yes,
submit,
yes,
Milos?
yes, yes. Please listen to the question.
My lords.
If it will not cover any of the cooperative bank, so none of the provisions will apply on you.
No, Milos, why I am saying so?
No, you see,
Vis-a-vis
when-
amalgamation.
why, you see, you cannot pick and choose, no, that this rule will apply and this rule will not apply.
That is anything, Milos. It has got a split capacity, Milos. Kindly appreciate one thing. It is at one hand, it is a society within the meaning of the Cooperative Society Act. On the other hand, it is a bank within the meaning of the RBI Act.
Okay, just a moment. So at least this position is clear that according to you,
It is a society, central society, district level cooperative society, district level
you
cooperative
just
society.
term the word you want to be
This
used
is a
in the
district level cooperative society.
society under the act.
Under the Cooperative Society Act. And it is a bank within the meaning of the RBI Act.
You have used the term district level cooperative society.
Why, Milos? Kindly
Has
repeat.
it been defined under the act?
I will see, Milos, what I am saying so. Milos, earlier it was a 3-tier, state level, that is central, district level, district central cooperative society, and the Milos primary level, primary agriculture society PACS, which has been sort of it converted to 2-level now. So earlier all the district central cooperative banks were Milos the second phase, that is the district level central cooperative society. And the state level Milos there was no bank. For the first time in the state Milos conceived the idea of having a central cooperative bank in the year 2011. This Milos all
You
problems
say that
started.
there was 3 level. Initially, what was the name of the state level?
At the state level, Milos, earlier there was different societies, Milos, like Milos, Land Development Bank, like Biscoman. There are several Milos state level society, which were Milos the central society.
But cooperative society was not there at the state level.
All are cooperative society, Lordship. Only level is Milos central, district, and primary. All have Milos different bylaws, Milos, all registered under this act.
Okay.
Only a structure is Milos the issue whether it is a central level, if it has a state level, it will have a branch in district level or the primary level.
That's right.
If it is the district level, it may have a branch at the block
right.
level or the
Fair
primary
enough.
level. But all are cooperative society, your lordship, registered under the Act and have a different bylaws and different administrative structure as a whole. Now, my lords, instead of wasting my lord's time, I am trying to satisfy your lordship that when this cooperative bank was conceived within the meaning of a cooperative society, it was the year 1981. And it will be apparent from language of the Rule 39 itself. I will place immediately Rule 39 your lordship. Lordship will get immediate the idea why this bank does not come under Rule 39. It is amply clear from the wording itself. But first of all, my lords, I am trying to justify your lordship. Rule section 44 AK was invoked by the state. In principle, concurrence was granted by the RBI by saying that it will be subject to willingness and ratification by the governing body of the each society. District level cooperative bank, 8 banks were there. 7 concurred, amalgamated within the meaning of 44 AK itself. Now, my lords, on 11/10/23, the RBI granted in principle concurrence, my lords. It is Annexure A.
11/10/23.
11/10/2013. I beg your pardon, lordship. 11/10/2013. This document is an Annexure A to the counter affidavit of the RBI. MLS in principle. This is Annexure A to the counter affidavit of the RBI.
Yes.
Now, my lords, it says what? It was addressed to the lords NABARD that government has sought for. We in principle agree. You please issue necessary instruction. That instruction was issued by the NABARD, which is Annexure B to the counter affidavit of the state. Kindly have a pleasure of that.
Annexure B of counter affidavit
of the
of
state.
Which counter affidavit?
By the state first counter affidavit.
Date, please.
It is dated, lordship, 17 October 2013.
So this letter is addressed to NABARD.
It is addressed, no. The first was Annexure A of the RBI letter is addressed to NABARD.
Okay.
Annexure A, that my lords, kindly see the Annexure A of the RBI
I've seen.
counter affidavit, my lords. This is a small short letter. अरे वो नहीं पढ़ रहे सर आप लोग क्यों? Annexure A plus page 24 of the RBI counter affidavit. Kindly have a pleasure of that, notes.
But to give us the date, you see there is no.
Date, lordship, therefore, I beg your pardon, it's a small letter, my lords. This RBI says to NABARD,
You have to give the date of the affidavit. There are multiple affidavits without any leave of the court. People go on filing affidavits.
RBI affidavit dated 16/3/2023.
16/3/23.
Served on us 16/3/23. 16/3/2023. Reserve Bank of India.
Yes.
Sporter number 5 RBI. My lords, kindly have a pleasure. Annexure A, page 24. This is from the RBI, my lords, to the Chief General Manager, Institutional Development, National Bank for Agriculture, so and so. Amalgamation of 8 CCB in Jharkhand with Jharkhand STBCB. Please refer to your letter number such and such, dated such and such, so and so. We advise that we are pleased to accord in principle approval to the proposal of the government of Jharkhand for the amalgamation of 8 district central cooperative banks in Jharkhand with the Jharkhand State Cooperative Bank as per recommendation inter alia received from the NABARD. This approval may be conveyed to the government of Jharkhand subject to conditions stipulated in paragraph 2 of your letter. Now, where is that letter? That is letter Annexure B to the counter affidavit of the state dated 7/11/14 Millers. If I am correct. 7/1/14 2014.
Yes, and there 7/1/14.
It was filed in very beginning, 7/1/2014.
This is annexure A.
Annexure B to the
Annexure
counter
B.
affidavit of the
Okay.
first state.
Yes.
This is, my lords, from the NABARD to the Principal Secretary Cooperative Government of Jharkhand.
Yes.
कृपया उक्त विषय पर दिनांक 5/9/13 के अपने विभाग के पत्रांक संख्या 67 रांची का संदर्भ ग्रहण करें। इस संबंध में हम सहर्ष सूचित करते हैं कि आरबीआई ने आपके शीर्षांकित प्रस्ताव को इन प्रिंसिपल अप्रूवल प्रदान कर दी है जो निम्नलिखित शर्तों के अधीन है। फर्स्ट, बोर्ड ऑफ जनरल बॉडी रेजोल्यूशन टू बी पास्ड बाय 8 CCB and STCB indicating their willingness for merger. Now, pursuant to this, the board meeting was convened. And the result of the board meeting, my lords, has been already brought on record by the supplementary counter affidavit filed by the estate themselves. This is, my lords, dated supplementary counter affidavit filed by the respondent number 2. This is dated 13/3/2023.
Just a minute.
13/3/2023.
Page number?
Now, page annexure 5 I have marked the flap annexure 5 paging तो जो कटा हुआ है इसमें निबंधक का है ये
Page
इस तरह से लिखा हुआ जो पेजिंग पता नहीं चल रहा है जो इसमें हमको जो दिए हैं ये annexure 5 देखिए तो आपका काम
आगे पीछे पेज नंबर
ABC
नहीं है।
30 नहीं यही पेज 30 annexure E हमारा तो सब कटा हुआ है annexure 5 लिखा हुआ है
24/11/20.
24/11/13 grateful Milos. On this date itself, the general body meeting of the Dhanbad Central Cooperative was convened, and that general body meeting, that resolution I have brought in my counter. I will just immediately come to my lords. But this is the communication by the none else than the managing director of the bank, who is the government employee in the rank of the district cooperative officer. He says what, my lords, to this निबंधक so and so amalgamation के करने के संबंध में उपयुक्त समय कहना है कि सेंट्रल कोऑपरेटिव बैंक ने झनवान आमेलन करने के संबंध में निर्णय लेने हेतु 24/11/13 को बैंक डेलीगेट की असाधारण की गई थी जिसमें बैंक डेलीगेट सर्वसम्मति से एमलगमेशन के विरुद्ध प्रस्ताव पारित किया गया है। So 44 acre gone here and itself, my lords, that chapter is over in my respectful submission. Why I am saying so with all emphasis? Thereafter, my lords, everything happens. The estate etc. come thereafter. Before this, all of that happened. This writ petition was thereafter heard for the first time. Lords, on 20th December 13, 20/12/2013 को स्टे आया। Therefore, to say or to suggest, my lords, that subsequently the in principle concurrence of the RBI was altered only because there was a stay, in my respectful
What
submission,
is the date of alteration of the RBI letter?
later, that is annexure B. And you have a pleasure, I am coming to that. This is 18/11/14. 18/11/14
Stay order passed.
स्टे ऑर्डर 20/12/13 और आरबीआई का अल्टरेशन लेटर है 18/11/14 in principle.
So therefore, on that day there was a stay.
There was a stay. But what I say, my lords, the reason is not a stay. The reason is that the
Alteration date is?
alteration is 18/11/14. That nowhere says anywhere it is a stay, therefore I am altering. I'll just place it, lordship, kind pleasure. In my respectful submission, since in principle concurrence initially granted was subject to the resolution and willingness of the general body meeting on 24/11/13 itself happened, and that was turned down That is the basic reason, my lords, not to, my lords, accord for another in principle, because first in principle goes. Now, my lords, if lordship kindly have a pleasure, annexure B and C of the counter affidavit, this RBI that earlier I have shown to your lordship, that is dated 16/3/23. The state, knowing well that by the general body meeting it has been dropped, they did not resorted for the concurrence of this bank itself. They left the idea about it, 44 AK, and they resorted for 7 only. For 7, all 7 concurred. They expressed their willingness or were in loss. They amalgamated, my lords. Even the salary were not being paid to their employees at the relevant time. They were happy with this amalgamation. But this bank is the only bank, my lords, which have sufficient surplus fund. They were regular in payment of salary. They were regular in refund of the money in profit. Kindly have a pleasure, Mr. Annexure B, page 25 on what of the RBI. They nowhere says that there is a stay, therefore we are altering this. Page 25, my lords, kindly have a pleasure, my lords, of the RBI counter affidavit. Annexure B.
Annexure B.
My lords. Page 25, my lords. It is little blackish to me, my lords, but I will read it, my lords. From RBI to the Chief General Manager, Institutional So-and-so Development Bank, National Bank for Agriculture Rural Development. Dear Sir, amalgamation of 7 Central Cooperative Bank with the Jharkhand State Cooperative Bank. New proposal, permission. Please refer to your letter number such and such, dated such and such. In partial modification of the in principle approval accorded to the government of Jharkhand to the proposal of amalgamation of 8 district central cooperative banks DCCB with the Jharkhand State Cooperative Bank convened our letter dated so and so. We convey our in principle approval to the revised proposal to the government of Jharkhand for amalgamation of 7 DCCB in Jharkhand other than Dhanbad Central Cooperative Bank with the Jharkhand State Cooperative Bank. As per recommendation inter alia received from the NABARD, this approval may be conveyed to the government of Jharkhand. So it writes what?
So where is that letter of the government?
Plus they have not annexed. But it talks of 2 things.
No, this is important, no. Because this
They will have
government
to
has.
it is their
stated-
property, we have
You have
no
not
access
annexed
to
that
that.
letter?
Revised proposal.
Revised proposal?
Revised proposal to our NABARD, then NABARD to the RBI.
We have elected.
Where is it?
It is in our supplementary counter affidavit dated 13/3/2023.
Where is that?
At the annexure. At page number 36. Annexure I.
Kindly read this.
तीस 9/2016
पढ़िए जरा इसको.
30/9/16 ये जो 16 का है,
16 का है।
हम 14 का लेटर पढ़ रहे थे आरबीआई का, हम लेटर पढ़ रहे थे दैट वाज 14.
Annexure H, page 34. Annexure H, page 34 of the supplementary counter affidavit.
Let's kindly see this. 27th November 14 letter, Lordship.
No, 5/12/24.
हाँ भाई वो 92/23/5/12/14 लिखा हुआ है मिनट्स. If I'm correct, in hand it has been written, my lordships. झारखंड सहकारी बैंक के 7 जिला केंद्रीय बैंकों का आमेलन। कृपया उपरोक्त विषय पर निबंधक सहयोग समितियां So, it was for the 7 banks.
Please read this letter.
Grateful Willows. संदर्भ नवंबर 27-14 प्रधान सचिव सहकारिता विभाग झारखंड सरकार प्रोजेक्ट भवन चौथा तल्ला। प्रिय महोदय, झारखंड राज्य सहकारी बैंक के साथ 7 जिला केंद्रीय सहकारी बैंकों का आमेलन। कृपया उपरोक्त विषय पर निबंधक सहयोग समितियां झारखंड सरकार का दिनांक 12/5/14 के पत्र संख्या 67 का संदर्भ लें। इस संबंध में हम सूचित करते हैं कि भारतीय रिजर्व बैंक ने 8 जिला केंद्रीय सहकारी बैंकों जिला झारखंड सरकारी आमेलन के लिए दिया गया इन प्रिंसिपल अप्रूवल जो आपको 7/10/13 के हमारे पत्र संख्या 2683 के माध्यम से सूचित किया गया था में आंशिक संशोधन करते हुए 7 जिला केंद्रीय सहकारी बैंकों झारखंड राज्य बैंक में आमेलन के संशोधित प्रस्ताव को इन प्रिंसिपल अप्रूवल प्रदान कर दिया है। भारतीय रिजर्व बैंक मुंबई का इस संबंध में हमारे प्रधान कार्यालय के संबंधित दिनांक 18 नवंबर 18/14 के पत्र DCBR CORCB नंबर 5327 7.51 को हम इस पत्र के साथ अनुकार संलग्न कर रहे हैं। आपसे अनुरोध है कि कृपया उक्त पत्र के पारा 2.2.3 में दिए गए मार्गदर्शन के अनुसार आगे की कार्रवाई करें। सो दिस कार्रवाई फॉर 7 बैंक्स। भारतीय रिजर्व बैंक के दिनांक अक्टूबर 11-13 में सूचीबद्ध शर्तें जिसका संदर्भ पारा 2.3 में दिया गया है, हम आपको दिनांक 7/10/13 के पत्र संख्या 2683 द्वारा संशोधित किया था, इसका अनुपालन करना सुनिश्चित करें। सो कंकरेंस वाज नेसेसरी मतलब बोर्ड ऑफ डायरेक्टर्स जनरल बॉडी मीटिंग। चूंकि भारतीय रिजर्व बैंक ने अपने संदर्भित पत्र के माध्यम से आमेलन के लिए इन प्रिंसिपल अप्रूवल दिया है, इसलिए सभी शर्तों का अनुपालन करते हुए कृपया JSCB एक्ट 1930 के सेक्शन 44A के अंतर्गत भारतीय रिजर्व बैंक से आमेलन की प्रस्तावित तिथि के साथ स्वीकृति प्रदान करने का श्रम करें। Now, my lords, after all these formalities, the Annexure C of the RBI came. That is 2017. I'll have a pleasure of that, lordship. It's Annexure C of the RBI later. I, my lords, with all respect and humility, my lords, submits that the moment the Milos
See, there was an interim order dated 20/12/2013.
Grateful
An
Milos.
interim order is not a general kind of an order. There is a clear direction that until further orders, the respondents shall not proceed with any process of amalgamation.
Grateful Milos. Which
So
process?
therefore-
The 44 AK was Milos dropped much before.
This is 2012/2013.
Why the writ petition was filed? Kindly have a pleasure of that, Milos. The prayer. The context of the prayer has to be seen, Milos. What process they have adopted? Why this writ petition was filed?
Because
Writ
the
petition
process,
was filed
they
in a
adopted 39.
Grateful, my lords. So the court was only injuncted for 39, not for 44 AK, because 44 AK was over in my favor.
So the issue to be decided is
Is
that
only 39.
if there is a failure under section 38, whether there has to be a fresh approval to proceed under section 39.
My lords, the issue is, my lords, only one issue now. 44 AK not satisfied, dropped. They agree. Our, my lords, GB meeting is there. Kindly see this, my lords.
No, we don't need to see your GB meeting.
Grateful, my lords. The moment 44 AK is circumscribed by the, my lords, permission of the RBI. RBI permission is circumscribed by the, my lords, the general body permission. Two, my lords, riders. The ultimate rider went on in my favor. Much before the stay order, that is 24/11/13 itself. Writ petition was filed in a situation, had it was not that in 44 AK they were
44
reproceeded.
AK does not refer to Rule 38.
38.
38 also, right? All the proceedings with regard to rest of the 7 banks was taken under Rule 38.
44 AK.
No, Rule
38 का
38.
कहीं चर्चा नहीं होगी.
Rule 38 is also mentioned.
38 का कहीं चर्चा नहीं.
38 is a part
अगर
of
है
condition.
तो
कहाँ हुजूर?
अगर है तो
अगर है तो उसका जीबी का कंकरेंस चाहिए.
नहीं, मतलब इसीलिए ना जब आप बोल रहे हैं कि कुछ नहीं है तो थोड़ा सा कैविएट के साथ
My lords, I am sorry,
बोलना
lords.
चाहिए आपको.
38 plus I have to examine. 38 I have not examined. To be honest,
You
plus
have
the
not
court.
examined for last
I will be
decide.
totally plus honest to the court, plus I will not speak anything
I
plus
just-
lying. I have to be very truthful to the court, plus.
No, it is not a matter of being truthful. It's a matter
Because
of
plus this was
going
not
through the
issue.
documents.
It is 38 talks of plus voluntary amalgamation of the society. Kindly say plus 38. Let us be clear. I'll place 38, 39 both. First, I want to plus clear one doubt that on account of a stay, this 44A could not fructify against me. Rather, Malos, on account of dropping of the proposal in compliance of clause A of the letter of the Malos NABARD, they were not satisfied. It was dropped. Government well conscious that they are not willing to 44A, we cannot do anything. Therefore, they switch over to 39. Now, the only question is, Malos,
affidavit of the Registrar Cooperative Society dated 7/1/2014, annexing the copy of the NABARD dated 17th of October 2017. Right? The due
2017.
process as required under the provision of Jharkhand State Cooperative Societies Act 2008, it has been mentioned, and Jharkhand State Cooperative Societies Rule 38 has to be followed.
no, Malos, I beg your pardon, Malos. They have annexed Rule 39 only in their counter affidavit of 2014, Annexure A.
Leadership, everybody is missing out on one thing. May I just clarify? Leadership, just one thing.
If you do not read your papers, that's your problem. I will read your papers and pass them.
My-
to you.
It's a
Leadership,
counter-
RBI's first letter which I have enclosed, Rule 38 is incorporated by reference, as your leadership has pointed out. RBI's first letter of 11th October 2013, last line is very important, subject to conditions stipulated in paragraph 2 of your letter.
Correct.
So what is paragraph 2 of your letter? That letter is not on record. But there is a later letter which recasts everything which was there in the previous one.
Yes.
That later letter is at page 26 of the supplementary counter which your leadership has seen.
17th October 2013.
17th October.
It refers to Rule
Page
38.
26.
They
And
say
that
that there are
17th
no
October
reference to Rule
2023
38.
is
I am
what-
absolutely
what-
clueless. इतना लग्जरी से आप लोग केस करते हैं कि हमको तो समझ ही नहीं आता कि क्या आपको बोलना।
Rule 38 is the
No, it's
Why it
a
has
luxury
escaped?
for you, but not for the court.
Why it has
We are
escaped?
hearing
why-
your case at the cost of other cases, and you
I
are not
agree,
even
Malos.
aware.
I beg your pardon, Malos. Why I have lost? I was not focusing on that. There is a
See,
Malos. I beg your pardon
I'll
before
tell you
folded hand,
one
Lordship.
thing. I told you, no, you may not read your brief, but I will read your brief word by word and line by line, and also between the lines. So when I asked you twice, you said that Rule 38 has got no relevance.
Because it is voluntary amalgamation.
Whatever, because, not because, Rule 38 specifically mentioned in your documents. You say Rule 38 has got no relevance.
That's actually clause A was.
And I'll give that finding in my judgment. You expect that from me?
No. Sir. I correct myself, Malos. Clause A is the condition, Malos, that you get the concurrence of your GB. That was the Malos main issue.
Okay.
And therefore, that escaped to my Malos. I apologize for that, Lordship. Because the moment my London friend said, I was also Malos hungry to see it, Malos, and I have seen this, Malos. Now I amend myself, Malos. Now, Malos, the only thing, Lordship, I want to say that 44AK proposal dropped. Therefore, the state switch over to 39. That's the only thing I want to say. And then the next, Malos, duty cast upon us is, Malos, whether 39 is applicable or not applicable. This is what will the second leg of argument we will see. Now, Lordship, may allow me to, Malos, try to Lordship satisfy Lordship concerns.
Now I have understood your argument.
That 39 is not applicable. Why 39 not, Malos? I will place the 39 only for Lordship consideration only. And then 2 para with the RBI counter affidavit. More. Paragraph 11 and 12 with the RBI counter affidavit. Now let us kindly see the Rule 39 of the Corporate Society Act. If the registrar is satisfied, may I place it, Lordship? If the registrar is satisfied after taking into consideration the financial position of the two more societies, here Lordship will find that it is not a mere society, that there is a question of two banks. I have said, Mulos, under the Act, there is first society, then the second is bank also. It only talks of society. Then what is further say, Mulos?
Just a moment, Mr. Mudane. Then you have to argue that 38 is also not applicable. Because 38 also talks about societies only.
I'll come to that.
No, you have to answer this.
Mulos.
What do you mean you will come to
There
that?
was 38 I have not
38 is
examined.
applicable with the same language, 39 is not applicable.
Then could it, Mulos, we are learning, Mulos, little bit tomorrow, Mulos, then. I'll assist 38.
No. You
Very well, Mulos. Then Lordship, let me finish 39. 39 by itself will satisfy your Lordship that it is not applicable. Reading of 39 itself. Two or more society, such other matters related to the society as may be proper, that is in the interest of those societies to be amalgamated into a new society. Kindly mark, my lords. Here there is no new society is coming. It talks of what? Two society, their interest is adversely prejudiced. If it is amalgamated, both will be benefited and it will be converted to third society. Here what is happening, Millers? One is another society, that is a district level society, another is a state level society, and it is engulfed by the central society in its own. No creation of third society. It envisages altogether a situation where two societies running in loss or their interest is adversely affected. So amalgamated and created third largest society. So Millers, it talks of clearly, if those societies were amalgamated into a new society, he may by order in writing require the managing committee of the society concerned to convene general meeting of the central order, creditors thereof within 6 weeks from the date of the order for the purpose of considering the proposal to amalgamate the society into new society. Again, new society. In my respectful submission, with all respect and humility, there is no creation of third society. They are trying to usurp this Dhanwad cooperative banks by hook or crook in themselves, which is a profit-making society. Rest all 7 were loss-making society. They amalgamated, created a merged into the district society. So on the face of 39 on reading, bare reading itself, it is not applicable. It is forcibly they are trying to apply this because they are concerned that 44 AK we failed. All 7 GB agreed, this GB not agreed. Now, this is not applicable. Why? It is more so apparent from the para 11 and 12 the RBI counter affidavit. They say what, para 11 and 12 the counter filed by the RBI. I have submitted that since the very concept of cooperative bank was not conceived in the 1959, therefore this language of Rule 39. It will be more fully corroborated from paragraph 11 and 12 the RBI counter affidavit. They say here, my lords, that within the meaning of RBI Act, the cooperative bank came for the first time in 1965. I'll have a pleasure that paragraph 11 12 may just place it for also consideration. Counter affidavit filed by the RBI. Paragraph 11 and 12. May I read, Lordship, for pleasure, Lords? It is submitted until the year 1965. Cooperative banks were not brought under the regulatory purview of the BR Act, and as such, the banking business of the cooperative bank was not regulated by RBI till 1965. 12. That it is submitted that to prevent the emergence of weak urban cooperative bank and also to ensure the growth of cooperative banking on sound lines, in the year 1965 it was felt necessary to extend the provision of BR Act to cooperative societies which were carrying on the banking business. Accordingly, the Parliament enacted the Act 23 of 1965, called Banking Laws, within bracket applicable to cooperative societies Act 1965. And then Banking Companies Act has been, with a certain modification, made applicable to the cooperative society carrying the business of banking. The amending act came into effect from 1st March 1966 by inserting to the BR Act a new Part 5 which consists of Section 56 of the BR Act. My lords have got it, please.
Yes, I got it.
To the effect that provisions of the BR Act as in force for the first time being shall apply to or in relation to cooperative society as they apply to the banking companies, but subject to the modification laid down in the said section. Every cooperative bank is obliged to comply with the provisions of the BR Act as applicable to the cooperative societies and directions, guidelines issued by the RBI from time to time. Now, those 3 lines are very important thereafter, concluding lines. At the same time, it is relevant to state here certain provisions of the BR Act, particularly incorporation, amalgamation, and winding up were not made applicable to the cooperative bank. This clinches the whole issue, my lords. Even in the BR Act, they nowhere envisage the amalgamation of cooperative bank.
So therefore, they should not have granted any sanction for this.
Sanction was what? Therefore, the sanction, therefore conditional sanction, that to first take the concurrence of the general body of the bank.
If the amalgamation is totally outside the purview of RBI,
Therefore,
they could have said that no sanction is required.
Plus there is another way of appreciation, what I beg to humbly submit. There are certain provisions of law, my lords, which are not too rigid. They, my lords, granted in principle, therefore, subject to. This RBI Act, BR Act, nowhere provides.
Banking regulation.
At the same time, it is relevant to state here that certain provisions of the BR Act, particularly incorporation, amalgamation, and winding up, were not made applicable to cooperative bank. Therefore, in principle, subject to, not absolute concurrence. Always in principle, my lords, and always subject to satisfaction of 2-3 conditions. RBI is conscious that this is not in my power, not in my ambit, not within the ambit of the banking law. Because they are now bank full-fledged, not mere society, which is now, my lords, dormant status. The dominant status is the bank now. There is 2 status of the, my lords, this institution now. The dormant status is the society, and the dominant status is the bank. This paragraph, my lords, I am trying to convey to my lords with all respect and humility, totally oust the operation of Rule 39 of the 1959, because it came in 1965. That 44AK came in 1981. And the wording is, my lords, there, formation of new society. As such, your lordship, this case was filed in a situation where there was imminent danger, imminent apprehension of, my lords, being forcibly taken over of this bank by the state cooperative bank, by the state. Therefore, it came at the stage when this Annexure 3 was issued. Now, my lords, I will turn back to Annexure 3. One question was, my lords, raised in the beginning, that whether it is a mature writ petition or a premature writ petition. It has fallen from my lords in the beginning, I will remember, that up till now there is no final order of Rule 39. Why you have rushed to the court? We rush to the court rather than my shareholders rush to the court. That since 44AK was dropped, in principle, subject to condition was not satisfied, the government in all in a camouflage manner tried to overtake this bank by virtue of Rule 39. This is Annexure 3. Honorable Supreme Court has time and again have said that even if it is so-called or any action which is wholly without jurisdiction, or there is imminent danger of violation of any right, there can be a preventive writ petition. Instead of restoration of right, you can claim for the prevention of miscarriage of right. That writ the judgment, I will just one paragraph subject to lordship permission we will place for my lord's consideration. This Annexure 3 is the letter by which, when this 44AK gone, Annexure A was the order by the registrar to the managing director that to convene the meeting. Meeting was convened on 24/11, dropped, then this came. Now can you see this? Annexure 3 now in this background I'll not subscribe to the argument that there is a government concurrence or not, cabinet decision or not. All those things, fellows, I'm not taking up. I'm only on the issue, fellows, that Rule 39 was colorably invoked when they felt that 44A we cannot, because the GB is not ready, and that is the in principle requirement. So otherwise, this is a malified effort by the next 3 by the registrar at that time to circumvent the mandate of Rule 44AK, which is the only operational area now for amalgamations of the bank loans. Now, that judgment of Lordship kindly pleasure, this Kiran Pasa judgment, the Lordship has granted this extended the scope of Article 226. I have a pleasure of this Lordship. And even at this stage, my lords contest whether it is a case for invocation for Article 226 or not. Now, only one paragraph, subject to my lord's kind permission, lords. Paragraph 14. Yes. I am tempted to read this, because this judgment, has given a very wide latitude to the lawyers to file writ petitions.
We'll read it.
Grateful,
This is on the principle of 226.
Manus.
Okay.
Even at this stage, this can be we can invoke this 226 against Annexure 3. This is to satisfy my lord's consensus. Article 226(1) of the Constitution of India, notwithstanding anything in Article 32, empowers the High Court throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government, within those territories directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them, for the enforcement of any of the rights conferred by Part 3 and for any other purposes. And it also envisages making of interim orders, whether by way of an injunction or a stay or in any other manner in such a proceeding. Article 21, giving protection of life and personal liberty, provides no person shall be deprived of his life or personal liberty except according to procedure established by law. For enforcement of one's right to life and personal liberty, resort to 2226(1) thus has been provided for. What is the ambit of enforcement of right? The word enforcement has been used in Article 32 of the Constitution, which provides that remedy for enforcement of right conferred by Part 3 of the Constitution. The word enforcement has been defined by the Constitution according to Collins Dictionary. To enforce means to ensure observance of obedience to law, decision, etc. Enforcement, according to Webster Comprehensive Dictionary, means the act of enforcing or the state of being enforced, compulsory execution, compulsion. Enforce means to compel obedience to law, to compel performance obedience by physical or moral force. If enforcement means to impose or compel obedience to law or to compel to life, personal liberty has been guaranteed as a fundamental right, and for its enforcement one could resort to Article 2 of the Constitution or for issuance of appropriate writ, order, direction. Precisely at what stage resort to Article 226 has been envisaged in the Constitution. When a right is so guaranteed, it has to be understood in relation to its orbit and its infringement. Conferring the right to life and liberty imposes a corresponding duty on the rest of the society, including the state, to observe that right, that is to say, not to act or do anything which would amount to infringement of that right, except in accordance with the procedure prescribed by law. In other words, conferring the right on a citizen involves the compulsion on the rest of the society, including a state, not to infringe the right. The question is at what stage the right can be enforced. Does citizen have to wait till right is infringed? Is there no way of enforcement of the right before it is actually infringed? Can the obligation or compulsion on the part of the state to observe the right so made effective only after the right is violated? Or in other words, can there be enforcement of the right to life and personal liberty before it is actually infringed? What remedy will be left to a
See,
person?
you can't just go on reading like this. Which portion?
This is the portion, Milos. I have come just
It's
now.
2.5 pages
No, Milos,
paragraph.
this is the portion where from sorry, Milos, I should have started from this portion. When one has to come to the court, this was next page.
We are not non-suiting you as not maintainable. So why are you worried about it?
Sorry, Milos, then Milos,
We
it
are
is over.
deciding the
So
issue.
even at this stage, Milos, where no final order is
After
passed,
hearing so much, we are not
Grateful.
going to say that it is premature.
I am only trying to Milos, satisfy my Lord's concerns that where there is
We will
imminent
go by
danger
the
of violation.
statute, we will go by the pleadings, we will go by the law, we will go by the constitution.
So whether 39 is
And we
applicable
will
or not.
reject all such arguments which are not based on record.
Grateful, Milos. Not
As
this.
simple as that.
Simple argument therefore my is, Milos.
This is what my
That
duty is and this
44
is how I
AK
conduct.
failed, 39 they resorted, which is not covering our Milos institution. Not applicable, it's a collaborative device they have Milos adopted to engulf my bank to their Milos central bank. This is the nutshell argument, Milos. 39 is not applicable in a Milos cooperative banks. It is not simple society, it is dominantly now banks.
And let me record your submissions.
Not
Right.
grateful.
The learned counsel appearing on behalf of the respondent, Dhanbad Central Cooperative Bank, has submitted that the required exercise in terms of section 44 AK was already completed once the bank once the proposal for amalgamation was declined by the bank
On 24/11/13 itself.
on 24/11/2013 itself. The learned counsel submits that there is no question of applicability of Rule 39 of the rules of
1959.
1959.
59.
The learned counsel has also submitted that Section 44 AK was inserted for the first time in the year 1981 and the rules of under the Cooperative Societies Act was framed as back as in the year 1959 and therefore at the time when Section 44 AK was at the time when the rules were framed there was no contemplation regarding applicability of Rule 39 to the cooperative banks. The learned counsel has also submitted that though the learned counsel has also submitted that that initially there were 3 levels of cooperative banks: state, district and primary level, and subsequently the state had taken a decision to do away with the second level, but the mode and method to do away with the second level is required to be followed. He has submitted that the Dhanbad District Central Cooperative Bank was a profit-making bank and the state is trying to engulf a profit-making bank through the method by adopting the method under Rule 39 and forcing the bank to get amalgamated in the state cooperative bank. Correct? Correct? Not correct?
Forcibly they are trying to take over. That is what.
ऐसे लिखिएगा, forcibly they are trying to take over the profit-making bank.
Divorce the rule, Milos.
Divorce the rules. The learned counsel has submitted that The stay order was passed on 20/12/2013 by this court, restraining the respondents from undertaking
Rule 39 process.
the process of amalgamation, and the meeting rejecting the proposal was passed as back as on 24/11/2013 itself. The Learned Counsel has also referred to Annexure B to the counter affidavit filed by RBI, which is counter affidavit filed by RBI dated 18/11/2014,
No, by the state.
by the state dated 18/11/2014, to submit that there was an alteration in connection with the proposal for amalgamation. Yes, please check.
Annexure B was conditional for the amalgamation by the
Okay, Annexure B dated 18/11/2014, and he submits that the amalgamation was subject to certain conditions. The Learned Counsel has also referred to counter affidavit filed by Reserve Bank of India, paragraph 11 and 12. The Learned Counsel has also submitted that though the respondent bank has not specifically challenged the impugned order in the present case, but is fully supporting the case of the petitioner in view of the fact that the impugned order has been challenged by the shareholders of the respondent bank. He has also relied upon judgment passed by Honorable Supreme Court reported in bracket 1991 SCC 328 paragraph 14 to submit that the present case cannot be said to be a premature one, and the cause of action to file the case had become ripe in view of the action, in view of the manner in which the respondent state was taking the steps by invoking Rule 39, which is not applicable to the respondent bank. That's all.
Not to the bank itself. It's not applicable to the banks.
Respondent bank. You are only concerned with your bank.
वो Annexure B का डेट जो 17 अक्टूबर 13 है जो 14 होगा.
17 October 13 है. Anything else you want to say? That is all.
Plus that is crux of the argument that 39 is out is not covering us. They cannot
Yes.
forcibly take over ourselves. We are the
Then
independent freedom.
Can you just check whether the date of the affidavit is declared 18/11/14 is not.
नहीं state वाला.
What
Yes, I'm correct. 7/11/14.
7/11.
the date of the document.
Okay. Yes, sir. Kindly respond.
In rejoinder to your argument, let the first if the lordship can be permitted. The statutory provision which my learned friends the state has referred, let section 2N and 2O, let that may can be similar.
Pre-amendment or post-amendment?
And that is prior to amendment in the year 2015. But because the writ was filed in the year 2013, and at that time the 2015.
That's 2 and 2O.
Right. The Central Cooperative Bank, the definition N is Central Cooperative Bank means the central society. This word has to be taken note of. Central society engaged in the business of banking. Then what is the central society? That has been defined subsequently. The O, central society means a cooperative society which has any other cooperative society, and if the bylaw provides individual as its member. Well, this line is not relevant for the purpose of explanation, provided that it does not under the category of the primary society and apex society, means the central society, not the bottom level and not the top level. Let I make clear to you, Lordship. So that is the central society, neither the top level means the estate society and nor the primary society. So that's the definition, and the name of the bank is the Central Cooperative Society. This is
You are neither state nor primary.
exactly, and that's why
The respondent bank is neither state society, not
right.
So central society is
Middle society.
middle society.
Middle
So according to you, bank is covered by central society.
Yes, that's it. The central.
That's right. Got it. Then
Yes, my lord, that's the Central Cooperative Bank's definition. Central Cooperative Bank is the central society, and central society has been defined.
that's right.
So there, this is. My lord, so far, my lord, the other argument, which is purely a question of fact,
No, what do you want to draw out of this?
that we are the middle category, and that's why Rule 39 is not applicable, because it talks about the society, not in relation to the Central Cooperative Society Bank.
Excluding central cooperative society, Rule 39, it excludes you.
It do not includes me.
It need not. It is the general term societies. If you want to say some exclusion, then you have to show some
No,
exclusion.
this definition excludes me. Definition excludes me.
No, definition is, you see, other than primary society and...
Yes.
Yes.
So if the it do not includes me, the Rule 39 do not includes me. Had it been so,
From where are you reading this? I am not able to get it. That it does not include you.
well, had it been the central society, then it should have disclosed the entire definitions other societies which has been defined under the Act. So they are under the central society, that the special quality of the society referred in the Act.
Anything else you want to say?
It do not talks about the banking society, my lord. It says about the society. So my lord, there are two possibilities in the central bank. The first is they are partly governed by the cooperative society for certain purposes, and so far the banking acts are concerned, they are governed by the directions of the Reserve Bank. So had it been that, then for that a special provision, my lord, it has been argued by the Council for the Bank that the provision of Section AK will be applicable. So this, my lord, that aspect, my lord, so far definition part which the estate has argued. One important aspect, my lord, which I just want to point out to your lordship, on the other date, my lord, when I had argued that the rules of executive business, my lord, your lordship may kindly have the Constitution, my lord, Article 166. Article 166, clause 3, my lord, says that every state has to have its rules of executive business. Here, your lordship kindly recollect that the state of Jharkhand has also got a rules of executive business. Then, my lord, so far the rules of executive business are concerned, this is coming from the Constitution, and that rule has been framed. Then, my lord, so far the Cooperative Society Act is concerned, there are three categories: primary, central, and state. When the state government or cabinet takes a decision that there will be only two types, it has the effect of, of course, my lord, considering it to be purely a question of law, my lord, it has not been treated. Melody, if the state considers that the one tire has to be deleted, top state tire and primary tire has to be maintained, then it will have the effect of change in the statutory provision of the Cooperative Society Act. And that cannot be, Millard, I'm sorry, Millard, I'm saying, Millard, that this is not pleading, but considering it to be purely a question of law.
We are not in any academic discussions.
No, Millard, so far, on the facts of this case, on the facts of
on the face we are seeing, we'll see by whatever plea you have taken.
Well,
Even if it is a pure question of law. Suppose an order is without jurisdiction. At least one has to say that it is without jurisdiction.
Well,
Then only the other side will have the opportunity to say that this is where the jurisdiction lies. Merely by not pleading
Well,
anything, you
Your
just
Lordship,
cannot argue a
can-
case in air.
My lord, your lordship may kindly reject it, but kindly consider that when the state...
I have heard you. I have heard
No,
you
no,
on
I
that.
do not say that your lordship has not heard.
I have heard you. I have recorded it also, specifically
Right,
recorded.
right. My lord,
That's
even
it.
for this one...
Please, in rejoinder, you cannot repeat your
No,
arguments.
no,
I
not
have
repeating.
recorded, I have seen your 2N and 2O. What else do you want to
My
say?
lord, I am developing it to some extent by saying that when the cabinet has taken a decision, then that must be notified as required on the rules of executive business. Rules of
That I have already recorded
Ma'am.
in your initial argument.
And the provision is, my lord, the rules of executive business is in the chapter 2, read with schedule 319 of the
I
executive
just
business.
do not know. You can memorize your whatever things are, but things which are not placed before me, I can't appreciate.
My lord, on
Nor
the
do I have such sharp memory that I will have a
My lord, on the other
vision
day,
of that rule that you are talking about. We can't.
the rules, my lord, I have, if your lordship kindly have.
No, you see, I'm hearing you. There is no need to repeat it. I've recorded your submission, right? That will be reflected in. That is why I record the submission and upload it.
My lord, the document which the estate has now shown to your lordship, my lord, I am not objecting that. I am saying that it is not in conformity with the rules of executive
That's
business because the cabinet decision should have come by the resolution, by a notification. That is lacking. Here, just a decision of the cabinet that should have that can be made effective only after issuance of the resolution. There may be so many things in the file, but unless it is issued under the signature of the authority by a proper means, by a resolution of the cabinet, then only it becomes effective, otherwise not. So here, since it is a special knowledge of the estate under section 106 of the Evidence Act, the estate should have brought to justify its action that there has been a decision of the cabinet and the correct decision on 2002 for amalgamation. That was a
After the amalgamation, what is the name of the bank which has come up? State Central Cooperative Society. State?
Jharkhand State Cooperative
Jharkhand State Cooperative
Society Bank. Jharkhand State Cooperative Bank. तो पहले से existence.
पहले से exists.
पहले से existence.
So therefore, one last query to you.
Ma'am.
If the decision of 2002 goes, then
Okay.
all the amalgamation goes?
No, why? Why? Because they have consented. Other
No. If that decision goes, then even by consent, can anybody take away the statute? No. You see, kindly see the seriousness. Even the Jharkhand State Cooperative Bank is not a party before this court.
Well, we are not aggrieved with them.
No, you are not aggrieved with them, but you are aggrieved by a decision which has been partly consented, acted upon with qua 7 banks.
Well, the
Isn't it?
persons who have the grievance, the person who feels that they have got a certain injury from the certain order,
That's-
they only they.
That is all.
Yes. Well, they have short notes of argument if you have, kindly permit.
You have already given what else?
That was a list of it.
No, you have given short notes also.
Question of law.
To summarize one thing, they have taken, this is the fourth stage.
All your points were recorded. They have responded to all your points.
Certainly, but
And now you want to add any new point?
No, nothing, but only to reaffirm those points, my lord. The first, my lord, in they took.
No, you don't need to. I have already recorded it. I have noted it. There is no problem about it.
The short notes, my lord, I have prepared.
You can give whatever, but things which you have already argued, the judgment is going to be based on that only, no? The learned counsel for the petitioner in rejoinder has referred to section 2N and 2 within bracket O of the Cooperative Societies Act and has submitted that Rule 39 of the rules of 1959 does not cover a banking society. He has also referred to Article 166(3) of the Constitution of India and submits that the rules of executive business are required to be complied, and has submitted that the cabinet decision which has been produced during the course of hearing by the respondent is not sufficient. That's all. However, during the course
that
of
must be followed with the notification
That
of
I've
the
said.
results
the learned,
to complete it.
you will dictate the order, please.
No, my lord, I am submitting, my lord.
Yes, I have already recorded your submission. However, even today, the rules of executive business has not been produced before this court, and the fact is has not been produced before this court for consideration.
Lord,
That's
should
all.
I give, my lord, the rules of
Arguments?
executive business?
No. You can't give it like this. You have to produce and argue it at the time of arguments. Arguments concluded, pose this case for judgment on equal date. हम आपको देंगे. You will get a date. Right? State one thing I want to know from you. One small thing. This decision, Annexure 3, right? This particular decision, is it talking about the consideration of the financial condition of the bank to be amalgamated? Annexure 3?
No. It is only for the better administration.
Only for better administration.
Better administration.
And nothing more.
Nothing.
Upon a query
It
by
is not
this,
discuss about the any financial, what is the financial condition of
upon
the
a query by this court, with regard to Annexure 3, the learned counsel for the state has submitted that there is no discussion in connection with the financial condition of the respondent bank for the purposes of amalgamation. Right? It only refers to the administrative aspect, better administration of the credit to be given to the concerned beneficiaries. That's it.
Leadership of the full form of tax and lamps.
These both there are full form of packs and lamps. उनको दे दीजिए.
For one thing, I would like, Lordship has just asked the
You
financial.
just do not read the brief. Please don't. I know you have just missed out. You missed out, and
Argument I should have been.
I can't. You see, the client cannot suffer because of your lattice.
The argument I should have been. Financial issue is not considered. I'm too grateful, Lordship. This point should have been argued.
इतना देर बहस करते हैं लेकिन क्रक्स में पहुंच नहीं पाते हैं. हमको समझ ही नहीं आता है कि क्या कर रहे हैं आप. What are you doing? That is why I put a question to you. चलिए. Next case call.
Obliged.
For admission item 4, WPS 020 of 2023.
Petitioner appearing. Yes, petitioner.
In this case, it has become infructuous, where the petitioner challenged the dismissal order.
WPS number
As he has been
220.
restated, we have brought on record the
The
appellate.
learned counsel for the petitioner has submitted that on account of subsequent development, the present case has
Yes,
become
yes.
infructuous.
By appellate order, he has been restated, Your Lordship.
He
Appellate
submits
order
that by virtue of appellate order, the petitioner has been reinstated in service.
dated 12.
And accordingly, he does not want to press the present petition. This petition is disposed of as such.
साइन कर दीजिए.
It may be disposed of, that's okay. But pressed, it may be disposed.
Disposed of as not pressed. He does not want to press the petition.
Item 5, the rupees 331 of 2023.
Yes, petitioner.
Yes, madam.
What is it that you are challenging?
This is the matter of regulation, madam. Our regulation is under process, madam. This is pending, madam, since 2020, madam.
How do you say that it is under process?
Yes, madam. It appears, madam, from the annexure 7 and annexure 9, madam.
Annexure 7. Page
Yes.
number?
Page number 29, madam.
Yes, 29.
May I read, madam? उपयुक्त विषय के प्रासंगिक पत्रों के संदर्भ में ध्यान आकृष्ट करते हुए कहना है कि माननीय उच्चतम न्यायालय द्वारा सिविल अपील नंबर 16 तक राइजिंग ऑर्डर दे एसएलपी.
Where is the counter affidavit? What is your stand in the counter affidavit?
The state has not filed a counter affidavit, but JEPC has filed a affidavit. In that regards, on the previous occasion also, leadership a similar matter wherein the JEPC has annexed one annexure A. A similar matter has been dismissed from leadership's court itself. And on the previous day, petitioner had taken time to see whether that matter and this matter is similar or not.
Yes, my matter is a different matter because the claim of the petition is under process matter. Therefore, my case is a different matter.
If it is under process, you pursue your process. Don't press this writ petition. Because if you have any, we cannot give you a guarantee of a positive order, right? Suppose there is any adverse order against you, then under such circumstances, it will be an impediment on the part of the respondents to give you the relief. If it is already under process, kindly pursue that.
Yes.
It is in the best of the interest of your clients. If it is under process, you pursue it. Don't press this writ petition at this stage.
For the moment, only annexure 9 mechanism.
Then I will not allow you to withdraw. Once I disclose my mind, I will not allow you to withdraw. It is absolutely your choice.
How to take instruction on the phone?
Instructions.
How to withdraw करने के लिए?
You have seen the order passed?
Yes, madam, I have seen, madam. I have seen, madam, that order, madam.
JEPC block resource persons, cluster resource, it's the same thing.
No, madam, it's because, madam.
What is your status? Status of the petitioner?
Yes, madam. इसीलिए कहते हैं एक बार इनका कहना है कि we are not the employees of the state government, madam, under the JEPC, madam. But just mechanically see, madam, the annexure 7, madam. And annexure 9, madam. We are employee of.
This is just a circular, right? Where is it under process? From where do you say that it is under process?
Yes, madam. Annexure 7 and annexure 9, madam. Annexure 9, madam. Name of the
Annexure 7 is just a circular. Where is annexure 9?
Annexure 9 on page 33, madam.
33.
Page 33, madam.
Your name is included in the list?
Yes, madam.
All of you?
Yes, madam. Item number 26, madam, and 81 and 86, 88, madam. Page number 34, madam. Page number 26, madam. Dharmendra Kumar. And thereafter, madam, item number, serial number 81, madam. Shyam Kumar Lal.
Where is Arjun Kumar?
Arjun Kumar, madam. 26. Dharmendra Kumar, madam. Petition number 1, madam. 26, madam. Shyam Kumar Lal Malur and Navin Kumar, 88 serial number. The answering respondents Malur who filed the
You see, you
confidential-
have already, it is already under process.
Yes, Malur, therefore.
So,
Plus-
whatever it is, why this letter has been issued?
Let's kindly see this letter. I'll clarify. I am the person to satisfy your lordship.
Yes, why this letter has been issued?
Plus, this letter has been issued in total misconception of fact. Kindly have a pleasure of
So
this
take
letter.
it to a logical end, please.
Plus, this is the covered by my lord's judgment. Line by line, it is covered. It is covered. The field is occupied by the judicial plus dictum already.
You see, that is why I am telling him that he can pursue his remedies.
Plus,
Don't
if
invite
he
an order.
wants to burden the machinery and chalking the same for the undue litigation, which is covered by the occupied by the judicial dictum, lords, I have nothing to say. I am here to assist your lordship with all effective laws.
Have you gone through
Assistance.
this order? We have referred to this order.
Kindly stimulus this.
7349.
I have gone through Malur. My case is the different Malur. As because Malur,
They are same person, we are
as
same.
because Malur, he himself they stated Malur, the employees are under the Jharkhand government. Malur, yes.
आप अपॉइंटमेंट लेटर लगाइए देखिए
हाँ appointment letter भी है.
Where is your appointment letter?
हाँ, yes,
Yes,
Malur.
let us see
Appointment-
this.
First mechanism see Malur, the annexure 1 Malur. This is the circular by which the advertisement pursuant to that letter Malur, advertisement was issued Malur.
Annexure 1.
Annexure 1 Malur.
Where is your appointment letter?
हाँ appointment letter Malur, annexure 3 Malur.
No, this is the advertisement annexure 1.
Annexure 2 Malur, advertisement
What is
Malur.
annexure 1?
Annexure 1 Malur, letter Malur, by pursuant to this letter Malur, advertisement was issued Malur, for appointment Malur of the petitioners Malur and other
It
persons.
was a contractual appointment or?
Contractual Malur. Contractual Malur.
If the,
This, yes Malur, this letter was issued Malur, the HRD Malur, the Human Manav Sansadhan Vikas Vibhag.
Now let us see the opening line of this letter.
yes,
सर्व शिक्षा अभियान कार्यक्रम के अंतर्गत kindly let us take this first line itself. It is written by the secretary to the deputy commissioners and what they are saying संकुलन स्तर पर साधन सेवी की सेवा लेने के संबंध में सर्व शिक्षा अभियान कार्यक्रम के अंतर्गत. So there is scheme work of first line itself and then मतलब से केंद्रों के लिए साधन से भी चयन किया जाना है संकुल स्तर पर अनुश्रवण को वर्तमान व्यवस्था स्वयं सो सारा एडवर्टीजमेंट देखा जाए. नेक्स्ट एनेक्सर 2.
yes.
सब शिक्षा अभियान ऊपर में लिखा हुआ जो झारखंड शिक्षा परियोजना
That's right.
सब शिक्षा अभियान गुमला. दिस इज अंडर दी स्कीम दिस झारखंड शिक्षा परियोजना.
Thereafter was the second line Malur.
This issue is well settled by this
Yes,
at
yes.
least now 5 judgments.
Second line Malur.
Now see this. आज भी उजर एक मैटर डिसाइड हुआ है कोर्ट नंबर 8 से ना. The judgment is awaited below. I will bring that. कार्यक्रम के तहत अनुबंध पर संकुलन साधन चयन के संबंध में प्रधान सचिव मानव संसाधन स्वयं सो राज्य परियोजना निदेशक स्वयं सो निर्देश के आलोक में प्रखंड स्वयं सो अनुबंध के आधार पर स्वयं सो. Now let's kindly see the next annexure 3 series. The appointment letter.
Yes.
Page 21 and then I will read the judgment that I have passed on to lordship. झारखंड शिक्षा परियोजना सब शिक्षा अभियान पेज 21. विज्ञान भवन गुमला सब शिक्षा अभियान सब पढ़े स्वयं सो. शिक्षा अधिकारी सह जिला कार्यक्रम पदाधिकारी. This is the substantive capacity under the sub shiksha abhiyan. He is in a split capacity.
That's
For the
right.
government school, he is a DSC. For this scheme, he is the district program officer. So and so, उपरोक्त विषय प्रधान सचिव कार्य के अंतर्गत इतना सब शिक्षा अभियान गुमला के चयन समिति के लिए निर्णय के आलोक में शर्तों के साथ आपका चयन सब शिक्षा अभियान के तहत सभी ग्रुप में संकुलन इतना के लिए किया जाता है. मतलब यह चयन पूर्णतः अस्थायी है. किसी भी समय बिना कारण बताओ आपका चयन रद्द किया जाएगा. आपका चयन मानदेय पर किया गया है. परंतु आपको मानदेय के रूप में 100 रुपये का प्रतिदिन
Honorarium.
प्योर ऑनरेरियम.
Yes, honorarium.
Then my lords,
Honorarium.
after having this plus the letter that my friend is relying upon is totally a misconception of fact. It's a nullity. This officer himself does not know
Thereafter
that to whom I am operating and how I am
subject matter of
operating.
annexure 9 Malur.
Now
Technically see Malur.
now see
Subject
this
matter.
judgment, my lords. I will not
Subject matter of.
Now let us see the judgment.
Let us see the judgment. I will not waste my lord's time. This judgment that my lord has passed, this is Arjun Kumar. This is the BRP CRP, same persons in other district. They are also BRP CRP, they are also BRP CRP under the same Subshiksha Abhiyan.
My matter is under process.
No, no, plus nothing at all.
So
Kindly see this
therefore, you
judgment.
do not invite, you should not be inviting an
Yes,
order
then
from this court.
withdraw it.
Because I will, once I have passed an order, I will not pass a separate order. I will not pass a different order.
If I am not
So
most
if you
covered by this
still, if you are still hopeful about it, that they might give you some relief, then you should not be pursuing this case. How many times? Am I here to advise you?
No, my lord. Just have taken instruction. Just
You don't need to take instructions.
just make any say my lord the annexure 9 my lord. What he
No,
stated my lord in
let
subject
us see,
matter,
let
my
us see. You just tell us that how this case is
He
different from.
himself says my lord ki the persons are the Jharkhand Sarkar ke adhinasth.
उसको लिख देने से this
No,
letter
first
will not be
line,
died.
ma'am.
Now, plus I
The
will place.
answering respondents my lord, he is the this person is my lord the answering respondents my lord who filed the counter affidavit counter affidavit. He himself they stated my lord the persons are the Jharkhand Sarkar ke adhinasth, and thereafter my lord he referred the persons who are the working it as daily wages my lord. The
Plus,
for-
again,
for-
plus he is
for their
misreading this.
regularization, my lord.
Let us read that plus what my friend is reading. We said झारखंड सरकार के अधीनस्थ
अधीनस्थ, हाँ, yes.
आगे पढ़िए ना, आगे पढ़िए। मानव संसाधन विकास विभाग समग्र शिक्षा अभियान के तहत, what is wrong in it minutes? He is reading in piecemeal. तहत जिले में कार्यरत प्रखंड संकुलन साधन सेवियों की सेवा नियमितीकरण के आवेदन का अग्रसारण फॉरवर्ड कर दिया. Is it create a right? And this will override this judgment of my lords. Kindly see this judgment now, my lords. This writ petition is filed for following relief. Exact the same prayer, my lords.
Same prayer.
Same
No,
prayer.
no, man.
I'm
My
coming
prayer
to
is
that.
different,
My
man.
lords,
Just
let us-
like
let me
Anisi
place it,
Madhu
my lords.
paragraph,
Let me place it. What they
Yes.
say so.
My
This is for the regulation. That is for the regulation.
yes.
You
That's
see,
the-
I'll tell you one thing.
The
The only
regulation
relief
services.
can be granted to you is that if you are covered by one or the other scheme of state floated for regularization, your case will be considered. Without a scheme, there cannot be an order of regularization, right?
Now, my lords, I will read this
Just
judgment.
a moment. You say that they have forwarded your case.
Yes, man. Forwarded.
If your case falls under one or the other scheme for regularization framed by the state government, you will get the relief. As simple as that. We are not here to pass an order to direct them to regularize you.
Only for expedition, my lord, to expedite our case.
Then I will say that you say that you are covered by one or the other. I will only say that if you are covered by one or the other scheme for regularization framed.
My
That
submission
is-
will be recorded. My lords, there is
I
no
will
scheme.
record your submission.
That observation is there, my lord, in order passed by your lordship in earlier case, my lord.
That's true.
So I have seen, my lord, there.
So, that's it.
That's it.
It
Same
is very
case.
simple.
Same person.
You see, things which are to be pursued politically, you are pursuing it in the court. It is absolutely a decision of the government.
Yes, my lord.
So how do you expect an order
my lord, in
from the
a-
court? We are
my
not.
lord, in
We
view
are
of-
not legislators, nor we are policy makers. We are not policy
And my lord,
makers.
in view of the judgment, another judgment of this honorable court, my lord, recently, my lord.
That was for the civil servant below civil establishment, not for the scheme purpose. All
Learned
these.
counsel for just a
Then, my lord, I
moment.
want to withdraw, my lord.
Learned counsel for the petitioner, after some argument, seeks permission to withdraw this petition.
Observation.
He submits that he shall pursue his remedy as may be permissible under law. The learned counsel for the respondents does not have any objection to the prayer made. Accordingly, this petition is dismissed as withdrawn. It will be open to the petitioners to pursue their remedy as may be permissible under law.
साइन कर दिया सर।